Hello everyone and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. Let's see what articles we will be discussing today. So firstly, from the Hindu we have courts drift and chinks in the judiciary's armor. Basically, this article specifically talks about the independence of judiciary and also that in what way should the judges be allocated the cases in order to maintain the independence of the judiciary from the other branches of the government. Secondly, policy lessons in Tamil Nadu's language formula. It is again from the Hindu, and as we know that the new education policy has given its three-language formula. So how it is not really applicable in the states and their education and language models like that in Tamil Nadu, and how Tamil Nadu's model is a kind of a world-class model will be discussed in this article. Thirdly, mixed messaging. So basically, this article discusses about the foreign direct investments and how much is it important for us to invest or to bring in these FDIs, and what are the obstacles in this way. Fourthly, financing economic recovery, which is almost a similar thing, but it is on a global manner. So here it talks specifically about India, but in the fourth one, it talks about a global economic recovery after the pandemic of COVID-19. And fifthly, in Supreme Court reading, the basic structure, the signature of Kesavananda Bharti. Now, as we know that this legend Kesavananda Bharti has recently he has expired, and his holy demise has actually made us to think upon the contributions and the entire role that basic structure case has had in the Indian Constitution. And sixthly, news and flash. So first, let's have a look at the LawSikho courses that we have for you. We have a lot of the courses, which is a judiciary test prep course. So you can have a look at it and get yourself enrolled. The link is there in the description box itself. You can also download from its landing page free study material for yourself to enhance the pace of your study. And then we have various other courses as well for CLAT and other courses. And we're very shortly coming up with UPSC law optional course as well. So this is the multiple choice question for the day. Which date has been chosen to be observed as the International Day of Clean Air for the first time in 2020? So, since from the time of 2020, this particular day will be celebrated as the International Day of Clean Air. So, the options are 5th September, 6th September, 7th September, or 9th September. If you know the answer, you can jot it down in the comment section below. Then for the descriptive question, we have Kesavananda Bharti versus State of Kerala case has been a turning point in the history of Indian Constitution. Discuss. So as we all know the contributions of the Kesavananda Bharti, so you have to enumeratingly you have to write it down in the answer. The answer must be written within a word limit of 250 words. So with this, let's first quickly start with the discussion of the first article that talks about the independence of judiciary and the Indian judiciary at large. So in the past week, two significant events or developments have taken place in the Indian judiciary. First is the almost everyday discussed thing, which was the contempt case against Prashant Bhushan, and the second one is the retirement of Justice Arun Mishra. As we know that if we talk about the Bhushan case, that is a contempt case against Prashant Bhushan in specific, the court had repeatedly been trying to coerce the contemner, who in the eyes of court was Prashant Bhushan, for an apology. Now, as we know that Prashant Bhushan, who also is a social activist and also is himself an advocate of the Supreme Court, so he was actually tried by the Supreme Court for violating the dignity or the functioning of the court at all. Through his two tweets that he had made, and the Supreme Court was of the opinion that actually those tweets were demeaning and they were bringing down the dignity of this institution as high as Supreme Court. So in the trial of that case, the court had asked and given a chance to Prashant Bhushan to actually come up with an apology. But as we know that Prashant Bhushan had actually denied clearly that he would not be, and he said that he would not at all be submitting any kind of apology because he believed that whatever he did was it was very much under his right to free speech and expression, and that his conduct was not at all in order to put down the functioning or the dignity of the Supreme Court, and that is why he was not at all apologetic about it. Also, he wanted to make sure that in the future as well, the people have this freedom to actually get into fair criticism. That is why now it displayed a self-proclaimed magnanimity. Now, because it says that after the apology, no kind of apology was seen coming from the side of Prashant Bhushan, the court actually came up with a verdict wherein the court fined Prashant Bhushan with a fine of mere rupee 1. So this must be rupee. So mere rupee 1 fine, and yes, he has been like awarded a simple imprisonment for 3 months, and that for the next 3 years he would be barred from any kind of practice, and that is his license would be invoked at least for the next 3 months, for 3 years. So, but this kind of verdict or this kind of punishment, to say, that has come from the Supreme Court has actually, questioned the very idea as to why the court was actually trying this entire thing. Because if at all the court really believed that he was a contemner and he really put down the dignity and functioning of the Supreme Court, then this kind of fine or this kind of punishment is definitely not in quantum or in proportion with the court's contention. So here, in some or the other way, it can be construed that the court just wanted to pop this entire issue out, and the court itself was not very convinced about convicting Prashant Bhushan in this particular case. And as we have discussed this, so it has debarred, the court has debarred him from practice. Please mind, it is a term of 3 years and not 2 years. So this is the first thing that has been discussed in this article. Now, for the second thing about the retirement of Justice Arun Mishra. So in this particular case also, Justice Arun Mishra was one of the deciding judges. So the entire work area, or the entire, working, functioning criteria or functioning method of Justice Arun Mishra has been brought into question. So it says that politically sensitive cases were mostly allotted to him, and the problems of master of the roster system has actually risen up. Basically, the master of the roster system refers to the privilege of the Chief Justice to constitute benches to hear cases. So in a way, it is considered to be, in the eyes of various Chief Justices, it is considered to be one of their discretionary powers, wherein they can refer the benches as to which cases will they be hearing. So in the similar manner, by using, or also we can say precisely by misusing, the master of the roster power, most of the politically sensitive cases were allotted to Justice Arun Mishra during his tenure. And that actually is not just the end of the story, but also in most of the decisions came in the favor of the executive, which means that instead of a rules-based or a right-based court, it has rather become a more of executive court. So which means it is favoring a lot towards the executive. So Justice Arun Mishra's decisions were predictably in favor of the executive. Supreme Court has drifted from right-based to executive court. So the solution to this can be legal certainty and a rule-based mechanism for allocation of cases. So basically, this is the very idea of this discussion today, which talks about the Indian judiciary and the independence of Indian judiciary, that it should definitely and completely be independent from any kind of influence from the either side, from the legislature or even the executive. With this, let's discuss the second article for the day, which talks about India and FDI, which is foreign direct investments. So before we start this discussion, I would want to give a small idea as to what do we mean by the foreign direct investments. Just as the name is suggesting, investments which are coming directly from the foreign companies or foreign enterprises, or be it any foreign source for that matter. So we know that in today's time, when globalization is so much, it is so important for all the nations to grow in a cumulative manner. So it is desired by all the nations that more and more companies from the outside world, and mostly from the countries that can offer good things and more even better investment, must come and invest into their own country. Now there can be various benefits to it. Firstly, your global relationships are made better, undoubtedly. Secondly, your GDP, which is your economic strength, becomes greater. Thirdly, there is a huge technology and every skill transfer for that matter, because if they come into your country that manufacture something with using a particular skill or something, there is a higher chance that you can learn or get that technology as well. So there are a lot of benefits that the FDI offer, and that is why India also has been focusing since a lot of time that more and more foreign direct investment is attracted towards India. Now, as recently also our Prime Minister stated that India is an investment destination. Now, as we know that very recently itself, Google also has decided to spend an amount of approximately $10 billion, which is a very huge amount for next 5 to 7 years for making the technological developments in India and developing a technological partnership with our own country, India. So similar investments are sought even more, and he stated that India is an investment destination, and it is serving as a manufacturing hub at the heart of global chains. So basically, this was his contention he put forward in the US-India Strategic Partnership Forum. Now, why? The reasons we should discuss as to that, why is it a good time for India to focus more on attracting greater FDIs to India? Firstly, use the disruptions created by the pandemic to lure potential investors. Now, as we know that in the times of pandemic, many countries, now as we know that China is one of the greatest hubs for manufacturing the products, as it has a huge capacity of skilled and unskilled labor, as well as of the industries where manufacturing can take place at a very cheap cost. But still, keeping in mind the coronavirus pandemic and various changing relationships in the global terms with China, many countries are trying to move out of China and shift their manufacturing hubs from China to some other country. Now, in this situation, India can be one of those mostly or highly benefited countries that can actually attract those countries to leave China and come to India for looking for a manufacturing hub. And in this thing, we should take advantage of the US-China trade war as well. Now, as we have been extensively discussing about the US-China trade war, it is almost 2 years now that US and China have been into this so-called trade war, and due to this, various relationships or the transactions that earlier took place very enormously between US and China have been disrupted. And in this place, India might be a good, keeping in mind various conditions that would be applied and various enhancements that we would have to make, but it can still having done this, all of this, India can be a very potential replacement to China in many scenarios. Then second, either by setting up or shifting their existing manufacturing bases or plants. So what they can do is either they can set up fresh plants into India, or they can just shift their system of manufacturing. Now, with this, we also have to deal with the entire issue that is persistent in the attracting FDI. So we talk about bringing in FDI in India, right? Then we also know how much is it important for our own economic growth, and what are the areas that we can offer, or what are the benefits that we can offer to the foreign direct investors. But with this, it is important for us to understand as to what are the challenges that India is actually facing, and why this dream of bringing in such huge FDIs in India has not been able to be achieved till date. Firstly, Atmanirbhar Bharat as one of the biggest resistance. Now, as we know that we have proclaimed this entire huge agenda, or the entire this plan of being Atmanirbhar. So what is happening is that we are many a times we are focusing a lot on providing a lot of resources to the domestic providers or the manufacturers or the traders. Now, in this situation, to keep the domestic products more competitive, we focus on providing more concessions to the domestic players. This actually, in many situations, disincentivizes various foreign direct investors to come into India, because they know that India, due to its policy changes, is trying to focus more in its domestic manufacturers only, and we might not be benefited a lot due to this scheme. But then again, and also in this edition, we have also seen this recent thing, which was there for go vocal for local, and also that now at all the e-marketing places and all the places, if something is manufactured, that is the source or origin of that particular product or service has to be mentioned. For example, if you're buying something from Amazon, Flipkart, or any of these e-commerce sites, you might be now able to see a particular product, and it would be written clearly as to made in India, or made in China, made in Indonesia, and so on and so forth. So that now you know that who is the source manufacturer or provider of this particular good, and only then you decide upon going vocal for local, and you can choose Indian products over any other products. In such a scenario, definitely it might bring this thing to the minds of the FDIs or the foreign direct investors, that their products or services might not be favored a lot by the Indians anymore. But then again, there is a point of clarification over here, which we should see. Being as neutral readers, we should understand that by Atmanirbhar, or being Atmanirbhar, or favoring the domestic players, we do not at all mean to become a protectionist state. what we need to do and understand is that India is trying to protect in order its own domestic players to give them a better off situation to grow and prosper more. But we not at all. We just do not contend to cut India's ties from our, importers and exporters services for that matter. And we are not at all trying to be a protectionist state. So there is a huge, it's a very hairline difference, but it is still a very huge difference between being Atmanirbhar, that is self-reliant, and on the other hand, being protectionist. So India is trying to be self-reliant and not protectionist, and that is why we definitely, if we have something good to, gain from the FDIs, we will definitely be offering them good stance. Secondly, not a party of the RCEP. This is one of the more similar examples. Now we have been discussing this at large, that India had dropped out in the final stage. It dropped out from joining the Regional Comprehensive Economic Partnership, which is till date this whole world's largest free trade agreement amongst the countries. Basically, there are currently 15 members of the RCEP, 10 are the ASEAN members, the members of the Association for Southeast Asian Nations, the ASEAN, and 5 other nations apart from it. India had to be the 16th nation, but in finality, it dropped out of being a member of the RCEP, keeping in mind that this huge free trade agreement would actually deter the growth of its own private and own domestic manufacturers, and that we definitely did not want. But of course, in future, even the members of RCEP have said this, that they're open to bring in India as the future members of the RCEP. So it's something for time being that we are doing, but yes, it is causing an impact on bringing in the FDIs to India. So this was all for this article. Let's discuss the third article for the day, which talks about Tamil Nadu's language formula. Now, we know that the National Education Policy 2020, which is so much into news due to its various, novel ideas also that it has brought, and some controversies and, some kinds of, backlash also it has brought in the minds of some people. So the author in this article says that the NEP 2020 misses out the vital empirical evidence of Tamil Nadu's language formula. Basically, the NEP, which has just been brought into the picture, it offers a 3-language formula. According to this 3-language formula, so we'll actually try to do it in a comparative way. We'll try to study it in a comparative manner. So on one side, imagine that we have this NEP 2020, and on the right side, the other side, we have the Tamil Nadu model, which is also quite similar to various world-class models like that in Singapore. So the NEP offers a 3-language formula, whereas the Tamil Nadu, which is the entire point of discussion in this article, it offers a 2-language formula. Now let's see that what is the 3-language formula first, and then we'll discuss upon the other one. So according to the NEP 2020 3-language formula, it says that all the students will learn 3 languages in their school. One would be their mother language. Like for example, if a student is from Maharashtra, so the mother language would be Marathi. If the student is from Gujarat, the mother language would be Gujarati. So one would be the mother language, the second one would be English or any foreign language, and the third one would be one more Indian language. So basically, it works around this 3-language formula. Whereas, on the contrary, in the Tamil Nadu language formula, it gives a 2-language formula, wherein it says that the student would be learning in the mother tongue, which is the similar point from this 3-language formula, and the other language would be English language, which actually is the global language, considered to be the language that can make you connect easily with the globe. So here we see that this very provision of one more Indian language is present in the NEP 2020, but it is absent in the basic Tamil Nadu language formula. This is the entire conflict and that has been discussed in this article. Now let's understand in detail as to what is the Tamil Nadu's language formula. So basically it was given by one of its chief ministers, C.N. Annadurai, and his vision according to this was, firstly, beyond Tamil and English, no other language would be taught in the schools of Tamil Nadu, which we say the 2-language formula, which is in contradiction with the 3-language formula given in the NEP 2020. So it says that all official languages should be equidistant. Now, please focus on this, as this is one of the most beautiful explanations or most beautiful reasons that can be given to this 2-language formula in the support of this 2-language formula. It says that all official languages, like in India, we have the official languages. So like all official languages, they should be equidistant to all the members of a multilingual society. So it says that if at all you want to make something, some particular thing as an official language, so so as we know that we have the official languages, but we know that the use of Hindi is very prominent in our official things as well. But here the Tamil Nadu two language model says that any kind of official language should be equidistant to all members of a multilingual society. Now, as we know that population of Hindi speakers are less than 50% in India, and still it is a majority. We can definitely say that it is a majority. But keeping in mind the whole population, only approximately half of the Indian people are Hindi speaking. But if we try to make Hindi as the only official language, and as we know that very recently there was a huge controversy where Amit Shah had actually proposed to make Hindi as the only official language and for all documentation and all the communication purpose for that matter, which was highly resisted by the South Indian states and specifically by Tamil Nadu at that point of time as well. So it says that if at all you want to choose a language to be your official language, then every member of your society should be equally distant from it. For example, if you choose Hindi as your official language, then people who belong to South India, Northeast, or even to the western part of the country might not be that comfortable with Hindi, but many of the North Indians would be comfortable. This situation is not ideal, and this is not what you would call to be equidistance, which means that not all the speakers are equally at an equal distance from that language. But for example, if you choose English to be your official language, then it is a new language in a way for every Indian in the country. This would mean that this particular language of English is equally at an equal distance from all the members of the society, and this would be a justified situation. So it says, so this is the very idea of having a two language model, wherein firstly you should be connected with your own mother tongue, the language that you know the best, the place where you reside, and secondly the only language that should be made compulsory and important for you is an English language thing that actually connects you equally from the language, all of the people equally from the language, and also is easier to connect with the world as well. So this basically is on the League One view model. This model has been very highly appreciated and used in the developed country of Singapore, and this is almost based on that particular model only. So this only thing is focused in Singapore as well, that they have chosen Chinese as their official language, and they have taken one mother tongue as well. So in other countries also it says like only mother tongue is the primary classes, English is taught only after the middle school. Here, as we know, the example of Singapore and Japan, they do the similar thing. And the mission Lee Kuan View in Singapore, so it also did the same thing. So basically it says that there is no point bringing in another language, and two language model is the one that is being followed by the developed countries, and so India should adhere to that more prominently. So Tamil Nadu and Singapore education standards, but the only thing that brings a conflict is that the education standards and also outcomes, if we compare from Tamil Nadu and Singapore, they're not comparable at all, and obviously the outcomes from Singapore are way better. But then obviously various other implementational schemes and implementation grounds and ideas also play a big role in it, and definitely if you have a good scheme and policy in hand, it can definitely be worked upon. And secondly, students struggle in both English and Hindi, English and Tamil if we talk about Tamil Nadu. But this still does not completely bring down the essence or importance of this two language model. Now let's discuss the fourth article for the day, which talks about the economic recovery. So basically in this article, it is talked about having a global or a cumulative, or to say a combined economic recovery from this pandemic of COVID-19. So over the last 6 months, countries in Asia and Pacific have experienced sharp decrease in export, remittances, tourism, and FDI. Almost the case that we have with India as well. So policymakers are under a dilemma about how to prioritize development spending, keeping in mind the fiscal reality, because obviously the problems at large are economic in nature. But different nations are facing different problems depending upon what kind of economy do they have. Like for example, in India, we were largely still based upon the agriculture for our economy, and it is such a good news for us that agriculture has still not been affected too much due to this COVID-19 pandemic. But there might be a situation like, for example, the Arab countries, the Middle East countries, which were largely dependent upon or we call about the petro economies that depend upon the export of crude oil from them. So when the transportation and industrial processes were halted during the lockdown, their economies were highly affected because the countries were not importing huge amounts of crude oil anymore from these nations. So they had to face different kind of economic challenges. So that is why the policy makers are under a dilemma. Now they have to understand as to how to be prioritized in this economic stress, that what steps should be taken the first. So some steps have been taken, like the UN, United Nations, has launched a global initiative for this, which is called as Financing for Development in the Era of COVID-19 and Beyond. So it has been brought from Canada and Jamaica, and they have worked cumulatively upon it. And it is basically done to safeguard the various sustainable development goals that we have. So there are three key areas where it would be functioning. Firstly, to address the challenge of diminished fiscal space and debt vulnerability, because we know that the people, they are not, on one side, they do not want to spend much because obviously there are no even opportunities to spend much. Incomes have been brought down due to economic stress, and due to this, a lot of vulnerability of bad debt. Like if you have taken a loan from some bank or any other institution, for example, you were relying on your income to pay back that loan, and due to COVID-19, that income is not coming. So how are you supposed to pay that loan? So you are vulnerable due to this debt. And fiscal space, as in there are very less of avenues to spend or invest into or gain back. So they want to work in this area. Secondly, ensure sustainable recovery consistent with Paris Agreement and Agenda 2030, wherein it talks about bringing green infrastructure, as in that whatever you are trying to do to enhance the economy, it should also keep in mind the climate change issue that we are facing so largely. And thirdly, harness the potential of regional cooperation in support of financing development. So it says that there is no way that countries can individually come out of this huge economic crisis, and we need to have regional cooperation amongst various nations to come out of this situation. With this, let's discuss the final article for the day, which talks about Kesavananda Bharti and the basic structure. Now, Kesavananda Bharti, Shri Padagal Varu. So, Shri Padagal Varu, the petitioner in the landmark case of, as we all know, Kesavananda Bharti versus State of Kerala, 1973. So, he, as we know, has passed away at the age of 79. So, let's see that what was the basic case. All of us know about it. We'll just brush it up since the topic has been taken up. So, issues are reviewing. So the issues of this case were, firstly, to review the 1967 Golaknath versus State of Punjab case, which ruled that the Parliament cannot amend the fundamental rights. Now, as we know, that some years before and after the emergency period, that was of 1975, so almost 5 years before and 5 to 8 years after the emergency period, have been a period of turbulence, basically constitutional turbulence, because in this time, the Parliament and the concerned areas wanted to bring more and more power to itself as much it was possible, so that they could bring in the laws as and when and as per their own discretion. So the second one was to check the validity of several constitutional amendments, such as removal of right to property from Part 3. As we all know, it was earlier a fundamental right, but then it was made a legal right under the Article 300A of the Constitution. Then the final decision was that, so we know that in this case, actually Kesavananda Bharti had lost the case. So this is it's one of the most exciting factors to know. But still, this case is one of the most important cases if we talk about the constitutional history. So fundamental rights cannot be taken by amending them, and certain parts are so inherent and intrinsic to the Constitution. So the first thing that came out, that fundamental rights cannot be taken away by just amending them, and removal of right to property from Part 3 did not violate basic structure. So from here, we actually got the doctrine of basic structure. So it actually originated from the German Constitution, and original Weimar Constitution provision were used by Hitler to make radical changes. And the new Constitution introduced limits to amend certain parts as basic law. So according to India, it formed the bedrock of judicial review. So we know that under Article 13, whenever the courts do any kind of review or the judicial review upon the laws made by the Parliament, the only thing that they use for referring the constitutionality or deciding upon the constitutionality of that law is the basic structure, whether it stands in consonance with the basic structure or does it violate it. If it violates the basic structure, it will be held as unconstitutional. So no law can violate the basic structure. Some basic structures are some of the components. Now, this is a very important concept to be known, that in India, we do not have a very rigid composition as to these would define to be the basic structure. Rather, it's a general kind of understanding, and it is open, definitely it is open to interpretations. But still, we have a basic thing in hand. So some of the elements are parliamentary democracy, fundamental rights, judicial review, secularism, fundamental rights, we have already discussed, etc. So reacting to the judgment, the Indira Gandhi government, so these are basically the reactions. So this is also one of the most fascinating things to know, that obviously, because a lot of power from the executive, or in a way the legislation, the parliament, had been taken away by this case, Indira Gandhi, being the then prime minister, was not at all happy. And that is why she appointed Justice A.N. Ray as the Chief Justice of India, who actually was quite junior as to the other judges, who were J.M. Shelat, A.N. Grover, and H.S. Hegde. But since they were in line and they supported this verdict coming from the Supreme, through this case, they were definitely not given this chance to get to the seat of Chief Justice of India, and superseding them, a junior judge to them, who was Justice A.N. Ray, was made as Chief Justice of India. So with this, let's discuss the news in flash. International Day, first International Day of Clean Air. So 7th September 2020 will be the first year to observe the International Day of Clean Air for blue skies. So it has been adopted by the United Nations General Assembly on December 19, 2019. The day aims to raise public awareness, demonstrate close link of air quality, etc., and how important it is for us to curb down the air pollution. Secondly, Iran and India talk on Afghan peace. During a meeting in Tehran, the defense minister of both India and Iran discussed ways to take forward the bilateral cooperation and exchanged views on peace and stability in Afghanistan. Now, as we know that India, Iran, and Afghanistan have been into a trilateral partnership also, when we talked about the development of Chahabhar Port as well as the Chahabhar Rail project. And for both India and Iran, it is thus important that peace and stability is maintained in Afghanistan, because only then this entire $1 billion project would be possible. So Iran cited the issue of recent reports on the safety of minorities in India as well. Thirdly, Foreign Contribution Regulatory Act 2010, FCRA Act also in short. The Union Home Ministry has recently suspended the license of 6 NGOs, out of which 4 are Christians, under the FCRA. FCRA license is mandatory for an NGO to receive foreign contributions. Like, for example, if you have a particular NGO and you want to draw any kind of donations or any kind of fundings or contributions from the outside entities or the foreign entities, you need to have a license from the FCRA according to the FCRA Act, and only then you can bring in this thing. This only thing is done in order to keep out any chances of black money or money laundering, etc. So this was all for today. We hope it was an informative session for you. And stay tuned with LawSikho for such more sessions to come. Thank you so much.